Breaking, Denaturalization and IRS, what every naturalized citizen must know. Denaturalization, stripping away U.S. citizenship, is no longer a rare, extreme action. It has now become one of the Justice Department's top 5 civil enforcement priorities. The memo announcing these priorities was issued on June 11. It made one thing very clear: this government intends to actively seek out cases where citizenship can be revoked. Historically, denaturalization was reserved for war criminals, spies, or terrorists. Today, the net is much wider. It includes cases linked to financial crimes, fraud, and even tax violations. This isn't speculation. It's written into official enforcement priorities. And it's why experts are warning that millions of naturalized citizens should be paying close attention to what's happening right now. Why civil denaturalization is so dangerous. Under civil denaturalization, there is no statute of limitations. That means the government can go after your citizenship no matter how many years have passed since you naturalized. If they discover evidence that you obtained citizenship illegally, or misrepresented a key fact during your naturalization process, time does not protect you. Even something that happened 10 or 15 years before you became a citizen could still be used against you today. That's why immigration lawyers are calling this a game changer. 2 main triggers for losing citizenship. The government generally relies on 2 broad reasons to strip citizenship. The first is illegal procurement, meaning you should never have been granted citizenship in the first place because you were ineligible. The second is misrepresentation or concealment of a material fact during the naturalization process. This includes lying, omitting key details, or giving an answer that the government later proves to be false. The most dangerous part? Even mistakes, not just deliberate lies, can be used if they decide it counts as a material misrepresentation. How the IRS became involved. The Justice Department memo added something that raised serious alarms. It explicitly included tax violations as a potential trigger for denaturalization. That means if you underreported your income, claimed deductions incorrectly, or made errors in your tax filings before you became a citizen, and failed to disclose them, you could be at risk. The memo also listed Medicare fraud, Paycheck Protection Program fraud, and other financial crimes, even those against private entities. This is a radical expansion of what can now be considered grounds for citizenship revocation. The hidden danger on the N-400 form. If you've gone through naturalization, you know about the N-400 application form. This is where a major trap exists. Part 9, Question 15A asks: have you ever committed, agreed to commit, helped commit, or tried to commit a crime or offense for which you were not arrested? If you underreported income to the IRS before citizenship, that's considered a crime, even if you were never arrested or charged. If you answered no to that question, and the government later gets IRS data showing the underreporting, that becomes their legal foundation for denaturalization. It's that simple, and that dangerous. DHS wants direct IRS access. The Department of Homeland Security is now actively trying to tap into IRS records to identify cases. They've already submitted a request for 40,000 specific records, hoping to match personal and financial data with immigration files. The IRS was only able to match less than 3%, but that's not stopping DHS. The demand for IRS data is growing, because it's one of the fastest ways to verify past financial activity that could be tied to misrepresentation during naturalization. Internal battles over privacy. The IRS has strict privacy rules. Sharing too much data with DHS could violate federal law. The former IRS commissioner reportedly refused to go beyond what the law allowed. Shortly after, he was removed and reassigned as U.S. ambassador to Iceland. This move has fueled speculation that there's intense pressure inside the government to expand IRS-DHS data sharing, and that resistance to this push comes at a career cost. How far back can they go? The IRS keeps different records for different lengths of time. In some cases, it's 3 years. For more serious matters, it's 5 or 10 years. If fraud is involved, there may be no limit on how long they can go back. That means financial actions you took long before applying for citizenship could still be examined today, especially if they can be matched with information from your immigration file. Who they're likely to target first. Experts believe investigators will start with the most recent records. Modern IRS records are more complete and easier to cross-check with immigration data. The technology for matching employment history, tax filings, and immigration answers is much stronger today than a decade ago. By focusing on recent cases, they can build evidence faster and move toward court action without sifting through decades of incomplete data. The green card process link. Here's where it connects back to your earlier immigration history. During the green card process, the government asks for your last 5 years of employment history. They don't always verify if you paid taxes during that time. But now, with IRS access, they could. If your immigration forms show you were working but the IRS has no record of tax payments, that's a red flag. That gap could later be used against you in a denaturalization case, even if you've been a citizen for years. The high-risk scenario. Imagine this: you had a job before citizenship where you earned cash income but never reported it. Years later, DHS accesses IRS data and sees no taxes were filed for that work. On your N-400, you said you'd never committed an unreported offense. That answer, combined with IRS evidence, could lead to a civil denaturalization case. The result? You lose your citizenship and could be placed in removal proceedings. Civil cases mean fewer protections. Unlike criminal trials, civil denaturalization cases don't require the same strict standards for evidence. The government just needs to convince the court that you obtained citizenship illegally or through misrepresentation. There's no statute of limitations and broad discretion for prosecutors. That means every naturalized citizen with undisclosed pre-citizenship issues could technically be on the government's radar. Why this affects so many people? Naturalized citizens make up roughly 7% of the US population, about 25 million people. Given the scale, the government doesn't have the capacity to investigate everyone. But it doesn't need to. Targeted data matches can quickly produce high-priority cases. Tax discrepancies are one of the easiest ways to identify potential targets. What you should do now. If you are a naturalized citizen, take a proactive approach. Review your immigration history and your IRS records. Make sure there are no discrepancies that could be misinterpreted as fraud or misrepresentation. If you have concerns, seek legal advice from an immigration attorney experienced in denaturalization defense. Don't wait until you receive a notice from the government. By then, it may be too late to act. Final word of caution. This is not meant to scare, it's meant to inform. Denaturalization cases are rare, but they are increasing under these new priorities. The combination of IRS access and no statute of limitations makes this an issue every naturalized citizen should understand. By staying informed, reviewing your records, and addressing any concerns early, you can protect yourself against one of the most serious enforcement actions in U.S. immigration law. If you found this update valuable, hit like, subscribe, and turn on the bell icon so you never miss a critical update. Stay safe, stay informed, and we'll see you in the next video.